Record. Is it recording now?
Yeah, we're good.
Okay. Okay. There's four Civil Rights Act that I want you to learn. I think they're very relevant to you as a person and as an individual. So that's why I'm putting them down because I want you to learn all four of them. Okay. The first one is the Ralph Civil Rights Act. Okay. And the Ralph Civil Rights Act says, in essence, that you can be awarded $25,000 to victims of hate crimes or even threatened hate crimes because of your race, your gender, your sexual orientation, or it's not clear, but your religion. Okay. If somebody engages in a hate crime towards you because of your race, your gender, your sexual orientation, or your religion, you can sue them. You can file a claim with the Civil Rights Commissioner of the state of California, and you can be awarded up to 25,000 plus your pain and suffering, plus your loss of wages or whatever you suffered because of that person's hate crime. That's called the Ralph Civil Rights Act. We went over the Civil Rights Act of 1964. When did we go over it? We went over it Thursday. We went over Thursday. It outlaws discrimination based on race, sex, color, religion, and national origin. It prohibits violation of voter registration, school racial segregation, and discrimination in public accommodation and in employment. Okay, the Unruh Civil Rights Act of 1959 prohibits discrimination from business establishments. I told you guys that a lot of these clubs were saying women get in free, men have to pay. And someone sued under the Unruh Civil Rights Act, and they made the club pay them for discriminating against males. Okay. And then there's the Bain Act. The Bain Act protects the fundamental rights of Californians from threats, intimidations, or coercions. It's Civil Code 52.1, and it was codified 1987. It protects us against hate crimes and civil rights violations. So you have basically four civil rights that you can allege if somebody threatens you with harm or violence, or even if they discriminate against you in a nonviolent way, you have ways to pursue an action against them. Now, Bain Act is not in your book. Ralph Civil Rights Act is not in your book because they pertain to California only. Unruh Civil Rights Act is not in your book because it pertains to California only. You can't go to Mississippi and claim Ralph Civil Rights Act or Unruh Civil Rights Act or the Bain Act because they're not applicable in Mississippi or Georgia or Alabama. They're only applicable in California. But the Civil Rights Act of 1964 is applicable throughout the United States. This is a United States law. But these other civil rights are simply based in California. Okay. And does anybody have any questions? Does anybody have any questions? Anna, you have any questions? Ileana? Leanna? Anybody
No, I
have?
don't have any questions.
Okay. Okay, great. Then we talked about Lauren Miller. Lauren Miller wrote a book called The Petitioner. If you ever get a chance to read the book Petitioner, I would advise you to read it. I read it when I was in law school. It's a great book. And what Lauren Miller argued was there was a time in history where if you sold your house to a black person, you could lose your house because your deed had what was called a restricted covenant. And it said, in essence, a white person could not sell their house to a black person. And it was written into your deed. And if you did sell your house, you would lose your house. It would go back to the previous owner if you violated that restrictive covenant. And so every time they went to court on these restrictive covenants to declare them illegal, the court always said, no, they're legal. It's a private contract. It's a contract between two parties, and the two parties can put what they want in their contract. And so nobody could win. Then finally, Lauren Miller came to the court and he said, these restrictive covenants have to be enforced. And since the courts are enforcing them, just like if you want a landlord to get out of your place, if you want a tenant to get out of your landlord property, you own apartments, you want a tenant to go out, you cannot use self-help to get the evicted tenant. You have to go to court to get the tenant evicted. So Lauren Miller argued that if you have to go to court to enforce these restrictive covenants that you can't sell to blacks, then these restrictive covenants are being enforced by the government. And if they're being enforced by the government, then the government is violating the 14th Amendment. The 14th Amendment says you cannot discriminate on the basis of race. In other words, you're supposed to treat everybody equal. And the Supreme Court agreed with them and they struck down all restrictive covenants. So restrictive covenants are now against public policy. They can't be enforced. I used to do research on deeds, and I went down to Riverside County Recorder's office, and there's restrictive covenants still on deeds. There's deeds with restrictive covenants still on them, but they are of no effect because they violate public policy, even though they're still on some people's deeds. But because they violate public policy, because they violate the 14th Amendment, they can't be enforced. Does anybody have any questions about that? I thought it was ingenious for Lauren Miller to argue that the government was engaged in racial discrimination by enforcing the restrictive covenants. I thought that was an ingenious argument. Everybody else had argued it was a contract issue, but he was able to argue the enforcement of restricted covenants engages the government in racial discrimination in violation of the 14th Amendment. So a smart move on this part. Now, Anna, you asked me about sexual harassment and retaliation. And retaliation, there's labor laws and there's fair employment laws that said you can't retaliate against a person for exercising their constitutional rights or exercising their state rights or their civil rights, or someone who reports sexual harassment, you can't retaliate against them. And they have labor laws that prohibit it. They also have fair employment laws that prohibit it. Okay? So you can't retaliate against a person for alleging sexual harassment. And then we talked about Pregnancy Discrimination Act of 1987. When we were growing up, they wouldn't show a man and a woman in the bed together. They had them in separate beds on television and everywhere else. Today, I see more and more television program. I even saw a commercial the other day where the woman is pregnant and she's selling products. And some of the newscasters on ABC News have been pregnant, and they still are doing the newscasts. But back in the days, they would get rid of a woman if she was pregnant, or they would take her off TV, or they wouldn't show her pregnancy. So America has come a long ways. And now, if you're discriminated because you're pregnant, you have the right to sue. Okay. We'll get to the defense later. We talked about age discrimination. If people over 40, if you discriminate against people over 40, they can sue you for age discrimination. And now this Greyhound bus really belongs over here under bona fide occupational qualification. Some of the defenses to racial discrimination are bona fide occupation qualification. For example, Greyhound, they would not hire young drivers. They said you had to be 35 or over to drive a Greyhound bus. And Greyhound was able to show that drivers over 35 were more mature, more stable, and better drivers. They were safer drivers. And the law said, based on that fact, that's a bona fide occupation qualification, that Greyhound could continue to discriminate against younger drivers and only hire experienced drivers because they're carrying a cargo across interstate lines. And they want only the best, safest drivers. So that was a bona fide occupational qualification. The merit system sits up there and says, in essence, if you pass the test, if you're qualified, you should have the position. If the test is not culturally biased and the test is fair and you pass the test, then you should get the job based on merit. And then seniority says, in essence, if you've been working there for a long time, they have the right to keep you on the job in spite of other people younger than you wanting to come on the job or take your place, that your seniority should be protected. Okay, so there was a case where they argued that this policy of this company that you had to have a high school diploma in order to get promoted was unfair to minorities because a lot of the minorities that worked for that job didn't have a high school diploma. And they were able to argue that though they were basing it on the merit system, the job didn't require a lot of education in order to do it. And that by requiring the minorities uh, to have a high school diploma was really unnecessary. It was really a way of holding them back and keeping them out of leadership position. I think the case is called Griggs Power Company versus Duke or something like that. But anyway, of course, it was unnecessary. That requirement of a high school diploma for this particular job didn't really require you to have a high school diploma. And so they were using that high school diploma merit system as a way to keep and exclude minorities from getting promoted. And the court struck it down and said, in essence, that the system was unfair and that it discriminated against minorities. Um, I talked about Age Discrimination Act, Americans with Disability Act. That's why you see handicap wraps coming up around restaurants because you have to accommodate handicap people because they're Americans too. You can't exclude them out of life. And so they have to have access to restaurants. They have to have access to business because many of them are just as capable and competent enough to do whatever is required of them. And so we have to keep the door open for Americans with disabilities. And then the Equal Pay Act of 1963 says basically if a woman is a janitor and a man is a janitor, they should both get the same pay. They shouldn't pay the man more than they pay the woman. I remember when I was in 11th grade, I worked for Kroger's in Michigan, in Pontiac, Michigan. And I had been there almost a year. And and I remember this white guy got hired after me, and he had only been there a month. And him and I got to talking about our pay, and come to find out he was making more money than I was. And I said, "How can you be making more money than I am? Because since I've been here longer." And I went and talked to my boss, and I said, "Why is he making more money than I am?" And he said it was because that guy was in the 12th grade and I was in the 11th grade. That's what he told me. What do you guys think about that? He said, because you're in the 11th grade and he's in the 12th grade, we're paying him more. He didn't say because he was white and you're black, I'm paying him more. He said because you're in the 11th grade, he's in the 12th grade. But what does grade have to do with our competency to work, our productivity, our experience on the job? What do you guys think about that? Anybody? Are you guys there? Is anybody here?
Yeah, I mean, I think if it goes based on experience, I mean, I think employers have the right to be selective when it comes to
Oh,
experience, but
okay.
when it comes to, because this is like a good topic. I remember in an English class many years ago, it's like we're discussing like, oh, like diversity, right? Should someone get hired because they meet a certain demographic?
Mm-hmm.
Um, a lot argued is like, no, it should be based on experience and it should be based on, because that would still be discriminating, right? Because if you're choosing that person to meet like a diversity demographic, it might, I guess in a sense be discrimination. So I think when it comes to experience, um, employers have the right to be selective, but anything else, I think that would just be on the basis of discriminating.
Okay. Can they be selective based on race, though? I mean, in other words, let's say that a competent black person is applying for a job and a competent white person is applying for a job, and they both have degrees and they're both equally talented. And they say, we're going to pick the white person because he's white. And we're not going to pick the black person, even though he's equally qualified because he's black.
That would be discrimination.
That would be discrimination. But then how would you prove it? How would you prove it? How would you prove that even though these people are equally qualified, that this person was discriminated against? When you go ask the employer, he's going to say, oh, no, it wasn't discrimination. Uh, we like things about this employee that we didn't like about this employee. So
I,
they're going to
yeah,
say that it's based on likability, but is it really likability? Okay. I talked to the students today about a dentist hired his assistant, and his assistant was very attractive. She was very beautiful. And so his wife came to work one day and saw his assistant and said, I want you to fire her. And he said, well, she just started. She's competent. She's capable. Why should I fire her? And the wife said, she's beautiful. And I think that you may leave me for her. So I want her fired. So the dentist fired the lady, the beautiful lady. So the lady sued. She said, I was discriminated against on the basis of my gender. She said, um, because I'm a woman, uh, they terminated me, and I want to sue for civil rights violation. And the Supreme Court of California said, beauty is not a civil rights, is not a right that's protected under civil rights. And therefore, they had the right to terminate you because beauty is not a civil right that's protected under either UNRUL or the Civil Rights Act of 1964. And so she was let go of her job just because she was beautiful. What do you think about that? Are you guys here? Anna, are you here? Leanna, are you here? What do
I'm
you guys?
here. I'm just processing and thinking of like everything that you said.
Mhm. Was that a civil rights violation? Was that a gender violation? Or was the wife correct? She had to eliminate her competition before she lose her husband to this beautiful assistant.
Well, wouldn't it be like morally wrong, but like legally, I guess, allowed?
Morally, yeah, definitely morally wrong and definitely legally allowed. But I'm just asking you, what do you think? What is your opinion? Do you think that the Supreme Court made the right decision in saying looks is not a civil rights protected by the Civil Rights Code?
I think, I mean, I think she could have maybe still like pursued like discrimination on gender because if she was a man and good looking, that wouldn't matter, right? In that situation.
Can't,
So,
the way they wrote the decision, it sounds like even a man can't sue under on the basis of looks.
right, but like what my argument is that if she was a man, this wouldn't be an issue. So it is in a sense discriminating based that she is a female. Yeah, she, according to them, right, she's pretty, but if she
Mhm.
wasn't a woman, would there be an issue? Like
Yeah.
that's the argument.
Okay, I see how you're looking at it. You're saying in essence, it's only she fears competition from a woman and not competition from a man. The dentist probably wouldn't be interested in a man, but he might be interested in a woman. So you're saying in essence, on that basis, it's gender discrimination.
Right. So like if this was in Iraq, I'd be like, did she discriminate because she's
Okay.
a woman? So it'd be like,
Okay. Okay, I see how you see it. Okay, what do you think, Leanna? Leanna, what do you think? Are you here?
I am sorry, my kids are just loud.
Oh, okay. All right. Take care of your kids. They're more important. All right. Well, Angel, what do you think?
I believe that looks should be protected by the
You
what's it
must
called?
be a handsome man. Are you saying that because you're handsome?
No, I'm saying that because you could be discriminated by the way people look. I feel like a pretty woman is also more likely to be hired than an ugly one, if that kind
Okay.
of makes sense.
Yeah,
But based on
it makes a lot of sense.
but based on what you said, I believe that he shouldn't have, even although his wife told him to fire the assistant. I feel like he shouldn't have because that's um
That's
uh
her own insecurities, huh?
yeah, that shouldn't be related to business morals.
Okay. Okay. What about now? A student was telling me that Abercrombie and Fitch, you young people probably know the place better than I do. What's the name of the company? Abercrombie and Fitch, or I don't know what the company's name is. But one of my students were telling me that the company had a policy of putting all the beautiful people up front and putting all the black people in the back of the warehouse or something he was telling me. At a warehouse, Abercrombie and Finch had all the beautiful people up front and all the black people working in the back. And he said somebody sued and won. And so I said to him, they must have mixed looks with racial discrimination. I said, if it had just been based on looks, it wouldn't have been protected. But because they combined looks and race, that's probably why they won. And he said that Abercrombie and Finch stopped the practice. They don't do it anymore. Did you guys hear about anything like that?
yeah, I saw the documentary. There was a documentary about it.
And so it was true then. What he said to me was true, huh?
They also violated like it was kind of more like labor laws. I feel like they were like not they were discriminating and not giving them hours and stuff like that. It was like a lot of things. It's been a while since I've seen it. I don't
Okay,
know.
dude, where did you see it at? It's a documentary.
I think it was on Netflix, I think.
It's on Netflix.
I
Okay.
think so, yeah.
I'm gonna look it up. I'm gonna look it up. Okay. But anyway, the way to get your case through the system is to base it on race, gender, sexual orientation, religion, or color, or your national origin. Okay. Your 14th Amendment prohibits discrimination. And I know we live in some dark times these days because right now we have a president who's not obeying the law, who's refusing to abide by the law. He's sending people back to uh, states where they were not raised uh, after they received the education. He's arbitrarily sending them back in defiance of a judge's order not to send them back. So we live in dark times right now. We live in a time where the law itself is not being everything is being done to change the laws that have been established for years, for centuries, are now being abruptly disrupted. So we live in some rough times. You know, the newspapers are called fake news. Anybody that asks the president a question is stupid, dumb, ignorant, and it's just crazy times, but it won't always be dark. We'll come out of this, and we'll probably come out of this better, and things will be better than ever before. But right now, it's pretty bad. Let's go to the next. The next. Oh, Malik, what did you think? What did you think about this discussion? I see you just came on. What did you think? Malik, what did you think? Malik, what do you think?
I thought it was pretty interesting, and I
Okay.
think more on what Angel was talking about, that like they shouldn't be judging by looks and stuff.
Okay. Okay. Thank you for your input. Thank you, man. Okay,
Hmm.
let's go one more. Let's do one more, okay? You guys know now, Thursday we're going to go over old exams. Thursday we will go over old exams. This is your last lecture is today. Thursday we're going to go over old exams. Next Tuesday we don't have class. And then that Thursday is what? December the 18th. Your final will be online. You just take your final online, okay? And upload it once you finish. Now, I'm asking everybody to do your exam in one setting. Don't do your exam and then get up and go party for 2 hours and come back and expect to finish it up. If you leave your exam, it's going to be you'll be suspected of cheating. Okay, unless you can give me a viable explanation why you had to leave your exam. Otherwise, you need to sit down and do your exam. You'll have 2 hours to do it. No, I think I'm gonna give you 2.5 hours. But the computer will tell me if you got up and went somewhere or if you walked away from the exam. So I want all of you to know you need to sit down, complete the exam, answer all the questions. It's only 10 questions, but some of the questions, it may be one question, but it may be compounded. It may say, explain the statute of frauds. And then it may say in that same question, explain the exceptions to the statute of fraud. Okay, does everybody see that? So that's all I'm asking you guys.
Will there be an extra credit question on this one?
Yeah, of course. That's
Okay.
an extra credit. 11 is 11. Uh, um, now, in my in-person class, see, this is the thing about in my in-person class, I gave the students with the best attendance um, a box of See's candy. I had 6 students that had perfect attendance. So I gave each one of them 6 boxes of candy because they had perfect attendance. They never missed one class. I don't see how they did it. I don't see how you make every class, but I had 6 students. And so now I told them that the top student with the highest grade point before the exam, I'm going to give $50 as a reward to the highest male and to the highest female. That's what I'm going to do to my in-person class. Okay. Now, with you guys is different. You guys, we're only online. I can't physically reach out to you guys, but I just want you to know what we're doing in the in-person class. Okay. And the last thing we're going to do is discuss The Fair Labor Standard Act. I think we talked about it last Thursday. 40-hour work week, pay if you do overtime. Over 40 hours, you're supposed to get time and a half. You're supposed to be paid at least minimum wage. People that are exempt are executives, administrative employees, professional employees, outside salesperson. Taco Bell shaved hours to avoid paying overtime. Taco Bell did this. Walmart had to pay 78 million because it forced employees to work through their breaks. Wow. $78 million because they would make you work. You're allowed 2 breaks in an 8-hour day, and they would have you work through those breaks. All employment in the US is for the most part, at will employment. Meaning, in essence, you can quit anytime you want. The boss can let you go anytime you want. When they say, I'll give you 2 weeks notice, that's simply a courtesy. That's nothing implied in law. In Montana, you have to have a valid reason for firing somebody. You can't just arbitrarily fire somebody. But at will employment, your boss can say, hey, my brother's coming from out of town. He needs your job. I'm going to let you go today. And they can do that. Now, lawyers, what they're starting to do is become ingenious, and they will incorporate your employment handbook. A lot of times the employment handbook will say, we only terminate people for good cause, or we only terminate people for egregious activities. Well, a good lawyer will incorporate that phrase into your employment contract and say, because you said this, my employee expected to only be terminated for good cause because you said it in your handbook. And they can incorporate that into your at-will employment and say that you needed a reason for firing them. You just can't arbitrarily fire somebody. And another way you can get around at-will employment is if you sign long-term contracts, like coaches. Coaches sign a contract for 4 years. I think one of these schools, LSU or one of these schools, Louisiana State, has to pay their coach like $37 million because they fired him before his 4-year contract was up. If you fire a coach before his 4-year contract or her 4-year contract is up, you got to pay him for the other 2 years or the other 3 years of the contract. So make sure you guys get contracts that are 3 years and 4 years as you begin to grow and as you begin to um, demand more from your employers. You can ask for a 4-year contract, a 5-year contract. You don't have to have at-will employment.
But wouldn't they have like what is it called? What is it called? Like a president or something, or like, oh, we can do early termination if you don't, like they can make it like conditional, right?
Well, all employment is at will. So if
No,
all
like for that one coach that got fired before his contract was up and they paid.
yeah, well, usually no, usually okay, for example, Coach Kipling or Kipler is leaving Ole Miss to go coach. Where is he going to coach? He's going to coach somewhere. But he's going to coach LSU. Well, he's not going to leave unless they give him a guaranteed contract. He's not leaving Ole Miss, and Ole Miss has offered him more money to stay. If he goes to LSU, I think he has a 4-year contract over, I think 70 million, something like that, close to 70 million a year. I mean, 70 million over the 4-year period. They have to pay him for all that contract because basically he said, I've committed myself to you for 4 years. And if somebody comes with me with offers, I basically told them I don't want those offers. So because I've detrimentally relied on your promise that you'd keep me employed for 4 years, you have to pay me. So they're not going to take a conditional, they're not going to take a you work for 90 days and let's see if we want to keep you. They're not going to take a probationary contract. Okay. Even in a probationary contract where an employer says, I'll hire you for 90 days and then decide whether or not I want to keep you. They can fire you anytime within that 90 days because it's an at-will contract. So the security is in getting contracts for 2 years, 3 years, 4 years. If you get a contract for 4 years, if you get a contract for 4 years, what does your contract have to comply with according to the statute of frauds? If that was on your exam, who could answer that? Anna, Malik, Angel, Ileana?
It means, you go through my legs, right? If it's more than a year,
Very good. Very
you
good.
also have to have it in writing.
All right. Okay. Very good. Well done. Well done. Well done. I'm impressed. Most impressed. Okay. That contract has to be in writing. What if I was to say, and the coach entered an oral agreement for a 4-year contract? What would you say on your paper? You would say that contract is unenforceable because it wasn't in writing, unless you can show an exception. What are the exceptions to statute of fraud contracts?
Um, there's admission, partial performance, promissory estoppel, and then there was one that you mentioned. There was a fourth one, but it's not really like counted. But I think you mentioned something like what was it? Like memo merchant or something like that?
Yeah, yeah. If one of the merchants sends a memo to the other merchant within 10 days and it mentions the agreement, the oral agreement in writing, and the other merchant doesn't object within that 10 days, then the law will accept that memo as proof of a writing. And then there's one more. Whenever the goods are unique under the UCC, like a Batmobile, um, the court will go ahead and enforce the contract because
Uh,
if it's unique goods, all right,
so would technically, if that were to be on the final, you would want us to name all five?
I would all the ones that are relevant to that question. If
Okay.
it's all five, the only way you would name all, no, I thought it was six. My legs with an S. It has an
Oh no,
S.
the exceptions, right?
Yeah, the
'Cause
exceptions. No, name the ones that are relevant to
uh,
that question. Name the one that are relevant to that question. Okay. So if it's relevant to that question, then name it. All right. Very good. Very good. Family Medical Leave Act. What the Family Medical Leave Act says, in essence, is if um, the Family Medical Leave Act says um, up to 12 weeks off work, unpaid leave, if you previously worked 25 hours a week for 12 months, you can get 12 months off to adopt a baby, to take care of the baby that you had. Not 12 months, you get 12 weeks off, which is basically 3 months. My son had a baby and he was working at the LAPD. They let him off for 3 months to be by his wife's side and help with the baby. Also, if you're getting a foster child, or if you're very sick, or if your spouse or your wife or your husband or your parents are gravely ill, you can take time off for 3 months to care for them. Your job doesn't have to pay you, but they have to keep the job open for you based on Family Medical Leave Act. And even if you're gravely ill or you're sick, you can take 3 months off to get well under the Family Medical Leave Act. And then I crossed out OSHA. OSHA is Occupation Safety and Health Act. Basically, the place where you work should be cancer free, shouldn't be hazardous to your health. We have a state board and a federal board that watches out for OSHA. Federal Unemployment Tax Act basically takes care of unemployment covers you if you ever lose your job. They pay you a low sum so that you can get back into the race, but it covers your basic essentials while you're waiting to get another job. Workers' comp, uh, for people who are hurt on the job, it basically compensates you for your loss of income and also helps you to get ready and train you for another job. A student were asking me about what if you're hurt away from the job? And I told them it's called detour and frolic, meaning in essence, if you're a pizza person and you go to the beach, and you get injured on the beach, they probably wouldn't cover you because it's not foreseeable a person delivering pizza is going to go to the beach. But what if you delivering pizza and you stop by to get some chicken at another place and you get injured? It's probably foreseeable that you get tired of just eating pizza. You want to eat something else. So your workers' comp people would cover you most likely in that case. Then we talked about COBRA, which is dental, medical, optical insurance. If you are let go from your job, as long as you pay for the dental, medical, and optical, they have to keep it on you for 18 months. As long as you pay the premium and the 2% administrative fee. If you're disabled, they have to keep it on you for 29 months. And the only one that's not up here is ERISA, ERISA. I didn't put ERISA up here, but it basically covers your pension. You know, a lot of times your employer will tell you, I'll match whatever you put in to this pension. I would advise you, if they say they'll match it, you should put as much money as you can in in your pension plan because that money can add up. You can have 80,000, 200,000 in no time while you're still working and they're matching your pension. So if your company offers matching pensions, please start putting money aside for your pension, okay? Don't go through life not taking advantage of matching pensions. Now, none of this is on your exam. OSHA, FUTA, workers' comp, ERISA, COBRA, none of that. It's not on your exam. Okay? That's what we taught today. You guys have any questions?
What about stress leave? Like, what is that under?
Workers' comp?
Oh, workers' comp? Okay, that's what it is.
Were you thinking about filing stress leave?
Oh, no, 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 not at all. Like,
Have you had it? Have
no,
you
because
had
in
it?
my old job at
Uh,
the old bank that I used to work at, I had someone in my branch that was on stress leave for like a long time, and I was like, "Is that legal?" I don't know.
a lot of it, I used to work in Pasadena, and my boss, he had me settle in PI case, personal injury case, automobile accident, slip and falls. And I enjoyed that. And then one day he told me, I want you to start doing workers' comp. And I'm like, man, I don't like workers' comp because a lot of those people are faking. Not all of them. Some of them are seriously injured. But a lot of people see it as a opportunity to make money and get out of the system. They
Yeah,
purposely are falling down the stairs, purposely falling off ladders and stuff so they can get injured, so they can, my brother, he got injured on his job and he didn't have to work another day in his life. They paid him disability for the rest of his life. My sister, she didn't have to work after working, and they kept it saying to me, uh, hey man, you need to get that workers' comp. You need to get that disability. But I like working. It's something about work that's redeeming and satisfying, and
yeah,
I like it. I don't mind going to work. I don't want that cheap hustle. I like, you know, uh, I was reading an article about John Gotti. John Gotti made a lot of money in his criminal enterprise, but he would take a lot of his money and gamble it away. He would just gamble. And I said, there's an old saying that says, easy come, easy go. But when you earn your money, when you actually have to work to, you don't play around with your money. You don't spend it foolishly, you know. You you manage your funds well, you know. That's what I think. But to each his own. But to each his own. Everybody's got a different thought about that, you know?
Yeah, for me, I personally enjoy having a career. Gives you like how you mentioned, like a sense of accomplishment.
Yeah, yeah, I think so. And then I like the interaction, Ileana, between me and the students. I'm with the students and I love to see those light bulbs come on. You know what I'm saying? You meet the students in the beginning of the semester and they're like, I don't know. And then you talk to them toward the end of the semester and like I just asked you, I said, hey, what do you think about this? You said, oh, that's statute of frauds. Oh, that's you couldn't have answered me like that at the beginning of the class.
Not at all. Yeah.
So you understand what I'm saying? That's the satisfaction, you know, hearing that one of my students is now assistant district attorney, or one of my students now owns his own law firm in Corona. That gives me satisfaction. That's what I'm happy about. You know what I'm saying? It's like, hey, I had a part in that person's life. That person is not the same. Okay. And I take a lot of satisfaction in that. All right. Anybody have any questions? I know I talked a lot today. I had diarrhea of the lips. My mouth was just running, 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 running. I had a lot to say. So please forgive me. Please forgive me if I talk too much. But anybody have any questions? Your exam again is December the 18th, Tuesday, December the 16th. You won't come to class. You're going to study, hopefully. And Thursday, we're going to go over, that's December 11th. Oh, class starts at 5 o'clock Thursday. At 5 o'clock, we're going to have class, not the usual 6 o'clock, even though it still says 6 o'clock on Zoom. We're going to meet at 5 o'clock, and I'm going to go over all exams. And if you see how my old exams are structured, you probably have a great idea of how my new exam will be structured. That's why I go over old exams. And that's Thursday at 5 o'clock. All right. And if nobody has any questions, that's it. Unless somebody has a question. Anna, you have any questions?
Um, I just want to make sure that I'm taking down the proper notes.
Okay.
In the case that we were talking about, I understand she wasn't able to sue, which I
Yeah.
agree with the, Supreme Court. I don't think,
Okay. You
um,
agree with that?
yeah, because I think
Are you,
beauty,
or Anna, are you an ugly woman? I've never seen you before. Are you ugly? Why would you say that? You agree with
no,
the Supreme Court?
well, I think I agree with them because I don't think beauty should be protected because to me, looks are sub subjective to each person.
Superficial.
Yeah,
They're
no, I
superficial.
think
Okay.
looks are subjective to each person. Like what I
That's
might find attractive might not
that's a
be what
good
someone else
argument.
finds
That's a good
attractive, you know?
argument. Yeah. That's a good argument. Yeah.
Um,
Beauty, how did they used to say it? Beauty is in the beholder or something like that. In other words, everybody
Beauty is in the eyes of the
a
beholder, I believe.
beholder. Yeah, thank you, young
Yes.
lady. Thank you. Thank you. Very good. Okay. Yeah, no, well said. You make a good point. Because my wife was at a party one time and
Mhm.
this guy told her, he said, will you want to dance with me? And she said, no. He said, you sure are ugly. That's what he said to her. And I said, he must have been blind because to me, my wife is fine. But the guy told her, you're ugly. But I think he did that as revenge against her refusing to dance with him.
Yeah, because he got rejected and hurt.
Because he got rejected and it hurt. Yeah, and he wanted to hurt
Mhm.
her. But you make a good point. It is subjective. So you agree with and then Ileana argued that it's more on the basis, she made more of the gender argument. She said that they're putting a criteria of gender on the female that they don't put on the male. So both of you guys are making good arguments. All right. But what else did you, I know there was something else you wanted to say besides that, though. Was that it? You say you want to make sure you were taking good notes?
Yeah. So based on like what I said,
Uh-huh.
if it was like one of the other civil right acts, she would have been protected, right?
If she had a sued in California and she was in California, what
Hmm.
other act do you think she could have sued under? Ralph or Unruh or Bain? Bain requires some type of intimidation, threatening. Ralph, no, requires you to be deprived of your civil rights or some kind of hatred. Ralph requires some type of hatred or threatening hatred. And unruh applies to business establishment discriminating against you. So you think she should have sued under unruh? Or what are you saying?
No, I was just asking like if it was something else, like let's say she was I guess like based on her race or like maybe her religion or her color, she could have sued.
Yeah, okay. I see what you're saying. Yeah.
Hmm.
Focus on fitting into that category rather than trying to create a new category, huh?
Hmm.
Okay. Makes sense. Makes a lot of sense. Okay. Yeah, she tried to step outside of it when she should have focused on one of the categories already given. But it's men. That Supreme Court that made that decision was mostly men. So makes you wonder if any decisions are biased.
Now, are there jurisdictions that do protect against appearance discrimination, even
That's a
though
good
the
question.
federal law doesn't?
That's a good question. When I say the Supreme Court, I'm talking about California Supreme Court has
Hmm.
said it's not a civil rights. It didn't go to the federal. It just went to the state of California. And they said it was not a civil rights. Beauty was not a civil rights. But I don't know if it's ever gone to the federal. Gives me something to do
Okay.
research on. It hasn't
Hmm.
gone to the federal, you know.
Now, I do have one more question.
Sure.
Now, you were saying about when we take like the final exam,
Yes.
what would be considered like going to the bathroom? Like, let's say I'm like flipping through my notes, which I'm not going to take like 5 minutes, obviously, to do, but
Hmm.
like, let's say I'm like taking a minute, will it like maybe flag it or because I
No,
just,
no,
okay.
I don't think a minute. I think what they're trying to do is the people who go off their screen
Mm-hmm.
and go to Google and do research and go off their screen and go to let's say AI
Mm-hmm.
to get their answer and copy and paste and post it on as their answer. I think what you should do is study before the exam, the way it's
Mm-hmm. Okay.
always been done, and then answer the questions presented, because you've studied. In fact, AI is starting to say now, lately, AI is saying this answer may not be correct. They never said that before. There's a possibility that this may not be the correct answer. They didn't say that before. Before, they were acting like it was the gospel truth. But now they're warning people uh, this may not be the correct answer. But my advice is study. Use 3x5 cards is my secret. 3x5 cards. Okay. Study the material, serious intent, definite in certain terms for contracts. Know what the terms are for UCC. Know the defenses. Put it on 3x5 cards. Study the 3x5 cards. And then listen to the questions that I give out on Thursday. And then decide, hey, I got a funny feeling these are the questions he's going to ask on the final exam. And answer them without cheating, without going to AI, without going to Google, but actually just straightforward answer. The other students in my class, they have to sit at the desk in my classroom and take the exam for 2 hours. or 2.5 hours. They have 2.5 hours. They have to sit there and take that exam. They don't get a chance to go look at AI. They don't get a chance to uh, check out Google in the middle of the test. And so it should be the same for you guys. You should have to study and then go forward and do your best. But I'm really looking, I looked at the monitor. It says this person started the exam at 6. They stopped at 7. They came back to finish the exam at 9. At 9 o'clock, they came back to the exam. That lets me know, well, what were they doing for 2 hours? Did they go partying? Did they go looking up the answers and then came back to the exam? That's what I'm trying to avoid. People leaving the exam to get the answers rather than studying for the test and then taking the test. That's what I'm really looking for. Okay?
Okay. Do you think the way you did it on the midterms, where you had asked questions and then it ended up being like some of the same ones?
Yeah.
Do you think you'll do that again?
Yeah.
Okay.
I guarantee you, I'll do some of the questions you hear on Thursday's meeting will be on the exam.
Okay.
And some of the questions I've already told you, people, especially the people who came to all these meetings, I told you several times what was on the exam. Like that one exam, that question about third party beneficiary contract. I don't think you were here last week. Were you here last week, Anna? Or were you here last Thursday? I don't think you were here. But we had
No,
a
I don't think so.
we had a question about third party beneficiary contract. You should watch the tape because that was a complicated question. It was about third party beneficiaries with assignments and assigners and assignees, and it was a combination of two types of third party donee beneficiary contract, and it had assignments on it too. I would go back and watch, I think the last 2 weeks tapes, because that will be on the exam.
Okay.
Okay. So I would watch tapes, previous tapes also, because I'm basically telling you, this is what's on the exam. This is what's on the exam. Uh, I'm rewarding the people who attend the classes or watch the videos. A lot of times you can't attend, but you can watch the videos. Ileana, you have a question?
Yeah, the IRAC that is due today.
Yeah.
Um, is that like based on current, like how am I supposed to base like I guess is it like a breach of contract type of thing that we're supposed to kind of
Well, what happened was he put his something in the shop and the guy didn't fix it in time. And so he lost business. And so the question was he liable for his foreseeable losses? And basically the court said, yeah, yeah, yeah. He argued he wasn't liable because he didn't know that his delay in fixing the product would cause him this foreseeable losses. But the law said, yeah, uh, it was foreseeable that if you don't fix my product in time, I'm going to suffer business losses. And they made the breaching party pay for those foreseeable losses. And so the two arguments are going to be the one side is going to say, I'm not liable. And the other guy's going to say, you are liable. That's the contrasting arguments under analysis. Are you raising your hand again?
Oh no, this is the same question.
Okay. Okay.
Okay.
Anybody else? All right, you guys. Hope to see you guys Thursday. We're going to go over all the questions. And if you don't come and watch it, at least watch the video before you take the exam. Because the video will be on 3C Media. Okay. You got a question, Malik? Malik, you have a question?
No, I do not.
Okay. All right, you guys. Been a pleasure.
Okay.
Take care of yourself. Study well.
All right. Thank you, Professor.
All right. Thank you. Bye.